Hello, I'm John Zamuda, Chief Deputy Clerk of the Probate Division, and your host for this edition of Clerk in the Community. Welcome. The Probate Division includes various legal matters for claims regarding estates, wills, settlements, withdrawals, guardianships, annuity contracts, and claims arising from problems with the Illinois Power of Attorney Act. This week, our discussion will focus on adult guardianship. Guardianship is the court appointment of a legally responsible individual or agency on behalf of a person who is not able to independently manage their affairs due to a disability. Remember, the Office of the Circuit Court of Cook County is the keeper of the records. The office provides information, not services. Yet we partner with different service providers to assist our customers with specialized resources for their different circumstances. Joining us today are two of our partners. Attorney Cheryl Lipton, Senior Attorney for the Center for Disability and Elder Law, and Attorney Amy Kessler, Director of the Intake Department for the Office of the Cook County Public Guardian. Would you both introduce yourselves and give a brief description of the services your office gives? We will start with Attorney Cheryl Lipton and then Attorney Amy Kessler.
Sure. I'm Cheryl Lipton. I'm a senior attorney and the pro bono coordinator at the Center for Disability and Elder Law, which we call CEDO. CEDO provides free legal services to older adults and people with disabilities who live in Cook County. We focus on guardianship, simple estate planning, housing, including landlord-tenant, and consumer debt and fraud. We're very community-based, so we believe in going into the community to meet with our clients. So we have educational outreaches, we have workshops, we have clinics all in the communities where our clients reside.
And hi, I'm Amy Kessler. I'm an attorney with the Office of the Cook County Public Guardian, and I manage our intake department and our adult guardianship division. The Cook County Public Guardian is Charles Goldberg. He was appointed by the Chief Judge of the Circuit Court of Cook County. And our office has primarily three divisions that serve three different roles. In our juvenile division, we represent abused and neglected children in juvenile court. In our domestic relations division, we serve as child representative for children in contested custody proceedings. And then in our adult guardianship division, we serve as guardian for individuals with disabilities.
Very nice. Thank you both for being here, ladies. Now we will discuss some general questions and scenarios regarding guardianship. I will start with Attorney Cheryl Lipton. When is guardianship necessary?
Well, I think you described it. It's needed when an adult, we're talking about adult guardianship here, just so we're clear. Mm-hmm. So when an adult is unable to make and communicate reasonable decisions due to a disability. That disability could be something that happened at birth or near birth, or it could be due later in life to an accident, a medical event, or even cognitive decline as people age. So because they're unable to make the decisions, and they haven't done a power of attorney document, which we're going to talk later, so they don't have someone to be their decision maker. So someone needs to petition to the court to be appointed a guardian.
Okay. Who appoints a guardian, and what qualifications must an individual meet to become a guardian?
So it's the probate judges that sit in the Daily Center. There's 5 of them, although hearings are still mostly via Zoom, but there are some in person. And during the hearing, everyone who wants to be a guardian are asked 4 statutory questions. Are they over the age of 18? Do they live in the United States? Have they themselves ever been found to be a disabled person in a court proceeding? And have they been convicted of a felony? Now, a felony conviction is not an absolute bar, but the judge needs to sometimes hold a hearing, do some additional findings to make sure it's still appropriate to appoint that person.
Okay. And regarding the felony, would that just be for the person that's taking guardianship or anybody living in the home?
It would just be, I believe, it's just the person who wants to be the guardian.
Just the person for the guardian, okay. I know that we've gotten that question before, so I just wanted to...
Okay, no, it's not something I've thought of, yeah.
What types of guardianship are there?
So there is guardian of the person and guardian of the estate. So at CEDO, we work on guardianship of the person only cases. And then guardianship of the estate, which is what they do at the Public Guardian's Office, is when you need guardianship over someone's money. So it's outside of Social Security, which is already a federally protected source of income. So if someone has, let's say, a pension or money in the bank or real property, they're going to need to establish both guardianship of the person to make the personal, the medical, those types of decisions, and guardianship of the estate for to handle the financial aspects. There's limited guardianship, which means they can make some decisions, but they need help or a guardian for others. There's also plenary, which is full guardianship. And actually, when the judge is making its findings in court, they do make a determination that that if plenary guardianship is sought, that's needed, that limited guardianship wouldn't protect the person, because they always want to do the least restrictive guardianship that's possible. There's also emergency or temporary guardianship if there is a need to have that guardianship established quickly.
Okay, very good. Thank you. And what is the difference between guardianship, power of attorney, and supportive decision-making agreement?
Well, all of these documents, let's just start out first, are documents for during someone's lifetime. So none of these are for documents for distributing assets after someone dies. So just to be clear about that. So we would always start with a power of attorney document. So with a power of attorney document, it gives someone, who we call the principal, the ability to name an agent, to make decisions for them if at any time during their life they're unable to do so. The thing is, they need to have capacity and they need to be able to direct what goes in these documents. So that's where, if they have the capacity and they have the ability to direct, then we would always do a power of attorney document, and we do a lot of workshops to help people with those documents. If someone hasn't named an agent, they don't have those documents, and the person is unable to make decisions, and they would need to petition the court to be appointed the guardian through a court.
Okay.
And supported decision-making is relatively new to Illinois. It's in the last few years. It is for people with intellectual disabilities, and it is meant so the individual has some decisional capacity, so they can make some decisions, but maybe not enough for the power of attorney documents. And so they can do an agreement where they name supporters to help them with certain decisions that they have to make.
Very good. Thank you. What specialized services does your office supply to families and individuals who are elderly or have disabilities?
So we run 2 advice desks. We have the Guardianship Help Desk, which we take in-person walk-in appointments at the Daily Center. We also do phone appointments. So that's for anyone wanting to petition for guardianship of the person. So we help them to prepare all of the paperwork, and often they will go and they will represent themselves pro se. We also take cases. We do guardianship of the person petitions where we represent them fully. We do an advice deck at the Cook County Clerk's office in the recording division. Once again, that one's by appointment, and we help people with preparing documents that they're going to record, so documents that are frequently recorded. We do, we're very community-based, as I mentioned, so we have 10 clinics throughout Cook County where we meet with people to see if, to talk about their legal issue. We also do power of attorney documents, we execute documents, we do wills, we do what's called a transfer on death instrument, which is a way of passing real property outside of probate, so it's another document that we do. And then we have workshops, so we do power of attorney workshops, we do housing workshops, and we do guardianship workshops. We actually go, we call it our mobile help desk, and we go into schools, some of the CPS specialty high schools and some of the others in the suburbs, where we go and we help families do the guardianship documents. So these are schools where the students are over 18, they're usually 18 to 22, and they're going to need to establish guardianship because in Illinois, the law presumes everyone can make decisions for themselves as adults, unless and until a court says otherwise. So these are families who will need to establish it when their child transitions to adulthood.
Okay, so quite a list of services that you provide. That's wonderful. Now let's bring in Attorney Amy Kessler. The Office of the Cook County Public Guardian steps in as the last manager for an individual who have no guardian. How would an individual become client to your office?
Sure, thank you. So an individual would become under our guardianship when a court appoints us to be their guardian. So really, guardianship has to be established by a court. So there would be a process to getting a court to appoint the public guardian as guardian. But in order for a public guardian to be appointed pursuant to the Probate Act, a person must have assets of $25,000 or more. So for public guardianship, the person would have to be over 18 and have assets of $25,000. If they don't have assets of $25,000 and you're looking for a third-party guardian, such as a public guardian, then that person would need to be referred to the Office of the State Guardian if their assets are under $25,000. But if the alleged disabled person has assets over $25,000 and they're 18, then that process would start with us, the public guardian. And those assets can be met by cash assets, bank account, equity in real property, or even a potential cause of action. And so to get the matter before the court, a petition has to be filed. A third party can nominate the public guardian to be guardian, so that could come from the court. Guardian ad litem could be directed to file a petition to nominate us, or we can file a petition seeking to be appointed guardian. We do not, though, file petitions to nominate third parties to be guardian. So if a family member wants to be guardian of their mother, sister, aunt, or someone in their family, we don't help them to become guardian. That's something CEDO might be able to assist them with. That's not a service that we provide. When we're doing a petition for guardianship, it's for the appointment of the public guardian to be guardian only.
Okay, that makes sense.
And generally that is because there isn't a family member.
That's correct. So we're also what would be considered a guardian of last resort. And so we serve when there maybe isn't a family member or a friend or someone in the person's life who's able to be guardian or who is appropriate to be guardian. Sometimes, as I will also touch on later, the population that we serve is often the victims of abuse, neglect, or financial exploitation. So there might not be anybody in their life who is able to serve as guardian. And so you need a third-party entity, and that's where we would come in.
Okay, that makes sense. What type of guardianship does your office provide?
So touching on sort of going back to what Cheryl was saying, we serve in all those very the same types of guardianship she referred to. So the public guardian will serve as temporary guardian, will serve as guardian of the estate, will serve as guardian of the person, and we'll do those in some combination of either limited or plenary. So we'll serve as temporary guardianship when there's an emergency. That, as Cheryl said, is usually done in an emergency situation when there's imminent harm to the person who's needing a guardian. A temporary guardianship is limited typically in scope and in duration. So as temporary guardianship, the public guardian will have the powers that are limited and detailed in the order only, and they're set for a certain specific amount of time, with the option to be extended, but they're for limited amounts of time. A temporary guardianship is typically in place while the court is making a decision on the underlying petition for guardianship, whether that's a plenary petition or a limited petition. The public guardian will serve in the guardianship that's been directed by the court, right? So that's going to either be after a hearing or an agreement of the parties. But we will serve as both guardian of the estate and person. And so it can be sort of a combination. We could be plenary guardian of the estate or full guardian of the estate, but limited guardian of the person. We could serve as guardian of the estate only, or we could serve as limited guardian of the estate and person, or some combination of all those factors. Okay. The public guardian serves as guardian for individuals from 18 to 100 plus. The individuals we serve live in their home with home care. They live alone. They live in congregate care settings, nursing homes, assisted livings. They have a variety of different strengths and needs, and so our guardianship encompasses all of that.
Okay. Who refers client cases to your office?
So referrals to our office come from a variety of sources. As I mentioned previously, many of the individuals that we serve have either been the victim of abuse, neglect, or financial exploitation, or were vulnerable to abuse, neglect, or financial exploitation. So to that end, we do receive a lot of referrals from community providers such as Adult Protective Services, law enforcement agencies. We will receive referrals from financial institutions, the court, attorneys. We receive them from hospitals, nursing homes, other care providers. We also receive them from families, neighbors, friends, things like that. Anyone can make a referral to our office. We have a referral process that you could access through our website. If someone were to go to publicguardian.org, there is a link to our intake and a way to make a referral there. They can always call the main number to our office. If someone has a question about whether a matter is appropriate for us or not, they're always welcome to call, talk to one of our intake staff who will be able to explain whether it's appropriate for us or not. If it's not appropriate for us, while we don't give legal advice, we're happy to give legal resources to someone so that they might be able to make that next step to find the appropriate help that they need.
Excellent. What specialized services does your office offer to their clients?
So the Probate Act dictates when the public guardian is serving as guardian, or any guardian, the duties and responsibilities for a guardian. It details what a guardian's supposed to do. It kind of gives that framework for what a guardian does as guardian of the person or estate. And when the public guardian is serving as guardian, one of our main goals is to try to maximize the independence of the person that we're guardian for, include them in decision making as much as possible, to the extent possible. But to that end, we have about 10 departments that work together in sort of a multidisciplinary team approach to meet our duties and responsibilities and serve the person that we're guardian for. Our departments range from our accounts department that handles all of the tax returns for the individuals we serve, and then our annual court accountings and real estate taxes. We have an assets department that collects and investigates for financial assets for any person under our guardianship. We have a benefits department that obtains and secures insurance, whether private or public, for anyone under our guardianship. So that could be Medicare, Medicaid. They also work very closely with other governmental entities such as Social Security or the Veterans Administration. We have our case management department, and this is sort of our social work department. That's the team that is really primarily responsible for visiting our person where they live and having that sort of regular contact. They work in conjunction with other members of our team to make sort of the important placement decisions, medical decisions, end-of-life decisions if that's necessary. But they also do some of the day-to-day things, scheduling medical appointments, making sure a person has clothing that they need, their favorite foods, those kind of items. We have a financial service department that pays all the bills. And imagine how many bills you as one person get in your life. So if you're managing that for tens or hundreds of people, that's a lot of bills.
Absolutely.
And also making sure all their income gets accounted for. And so that's a complicated task. We have a home care department that will manage the caregivers, that if a person lives in home with their care, or companion services if someone maybe doesn't live in their home but has a caregiver who visits them, takes them then on outings. We have the intake department, obviously, that manages referrals to our office. We have a legal department. I know this is a long answer, I apologize.
No, it's great. Very thorough. I like it.
We have a legal department that's a team of attorneys that represents the public guardian and then is our liaison between the court and the other departments. Our legal department, our attorneys do a wide variety of tasks, from visiting with the individuals that we serve to being involved in some of those difficult decisions we have to make about placement or end of life, pre-need funeral planning, to managing and selling real estate, financial planning. So that's the tasks they take on. We also have a dedicated unit, which is our financial recovery unit. As I alluded to before, many of the people that come into under our guardianship have been victims of financial exploitation. So our financial recovery unit, their primary task is to try to recover some of those monies through a court proceeding referred to as a citation. It could be a complicated process, so they are dedicated to that. And then lastly, we have a property department. So our property department manages all of the personal and real property of a person under our guardianship. So that could be from securing their real property, managing snow and lawn care, to selling any kind of personal property that needs to be sold to help pay for someone's care.
Okay, wow.
Yeah. Sorry, that was a long answer.
No, that's great. Thank you.
And just to clarify a little bit, so CEDO, we have a help desk that helps people who want to file themselves to be appointed guardian, and we represent people to be appointed the guardian, but we never become the guardian.
Okay. Thank you for that.
So we have very different roles.
Yes.
Yes.
If a person has a guardian, what may cause a guardianship to be dissolved?
So a person can have their guardianship terminated or vacated, what we would call as being restored. So if a person no longer needs a guardian, if they are now able to manage their own personal or financial affairs, they can bring that to the court upon a petition, or an interested person on their behalf can bring that to the court. And so they could have their guardianship dissolved or terminated. You may see other situations where maybe the guardianship isn't terminated, but you may need a change in guardian. Guardians will often, unfortunately, a guardian could die. A guardian may need to resign for circumstances in their own life, or on occasion too, a guardian could mismanage the funds of the estate. And so a court may also need to change a guardian. and have to appoint a successor guardian or renew a guardian. So that's also something that doesn't necessarily dissolve the guardianship, but it's a change in guardianship.
I see. Difference then?
Yeah, so maybe we could talk, maybe I could talk a little bit more about the difference between limited and plenary guardianship.
Sure.
So in a limited guardianship, the court will set out generally will reserve specific powers for the person under guardianship, or reserve certain rights for them, I guess I should say, for the person under guardianship, and then set aside certain responsibilities for the guardian. So in a guardian of the estate, let's say, if you had a limited guardianship of the estate, what you might see is in an order, and that order will be very detailed. It will have specific paragraphs that will give the things that are the rights that are reserved for the person under guardianship, and then the powers and duties for the guardian. So you may see that in a limited guardian of the estate, the person under guardianship has a right to receive an allowance of a certain amount. They have a right to give an opinion on the sale of their home. And if there's a disagreement between the guardian and the person under guardianship, that matter will go to the court for the court to decide. Because ultimately under a guardianship, the person under guardianship is a ward of the court. That's the technical phrase, right? And so the court is the ultimate decision maker if there's a disagreement between the person under guardianship and the guardian. So a lot of times in a limited order, those decisions will revert back to the court to make the final decision, but certain powers are reserved for the person. If you're talking about a person guardianship, the person under guardianship has a right to decide where they live in consultation with assistance from their guardian. They may have a right to make their own medical decisions, but the guardian can make them if and only when the person under guardianship lacks capacity to make medical decisions. Because a person under guardianship may need some assistance, but not all assistance. They may not be able to manage some of their personal affairs. They may be able to make their day-to-day medical decisions, but may need help deciding where to live. It's all on a spectrum. And I don't know, Cheryl, if you have anything you want to add.
I think one thing we often help, because we do a lot of guardianships for families whose children are transitioning to adulthood, and we often have both parents appointed. So you can have co-guardians, they're co-equal, they have equal rights to be guardians. I know that there's no bar on it, but we've never done more than 2. Have you done more than 2?
I've never seen more than 2.
Right. I've heard that you can, but we never have. So you can have co-guardians. So that is something that might be interesting for the people. The other thing is, so emergency or temporary guardianship is not like a faster guardianship. It doesn't just mean, oh, I don't want to wait a month to get my hearing, because it generally takes about 4 to 5 weeks to get a hearing. It means there's something going on. There's a medical decision that has to be made. There's a housing decision that has to be made. There's an immigration hearing that's coming. I mean, there's some very specific thing, and I think you mentioned it. The orders are very, very, it's not just general powers of guardianship faster. It's very specific powers. So you have to have a reason to do the emergency guardianship. Otherwise, you have to wait for the hearing for the plenary. And I guess we could talk, there are some requirements for the petitioner in order to become the guardian. There needs to be personal service on the person with the disability, which is generally done by the sheriff. No matter what their disability is, they need to be personally served with a copy of the petition and the summons. And then there also needs to be notice to interested family members. And you have to have a doctor's report, which is called a CCP 211. That report has to be completely filled out. It cannot be based on exam that's more than 3 months from the time you file the petition. So there are certain steps. This is things we go over at our guardianship help desk. But for people considering whether to file for guardianship, there are a number of steps, and these steps are very important. You can't get beyond them without providing them to the court.
Okay.
I would also add to that, if a person is seeking to be guardian of the estate for a family member, typically you need an attorney to do that. In Cook County, the circuit court rules, or there's certain rules that would say if you want to be guardian of the estate and you're going to be managing someone's money, other than Social Security income, you need to have an attorney representing you.
Because you need to purchase a surety bond, and you can't
Yes.
purchase a surety bond to protect that estate without an attorney.
I see. So you need legal representation because technically the estate would need its own legal representation? Is that right?
Well-
With the attorney?
Sort of. Yeah.
Okay.
Yeah. It's just a requirement that if you are going to be managing money, and then you have to have the surety bond to be bonded, like the insurance policy essentially is what that is how I like to explain it. to go through that process, and so that the guardian of the estate must be represented by an attorney.
Right.
I see. That
Yeah.
makes
But
sense.
if you're just seeking guardianship of the person, then many people file pro se, they self-represent. So they do not need an attorney to do that.
Okay.
But they should come to one of our help desks to get help with the documents. So
You can help walk them through. It seems like both
Right.
of your agencies have a very long list of services to kind of help people navigate this process.
And I will say, when people contact my office, and we're maybe not appropriate to help them because they want to be guardian for a family member, CEDL is one of the places that we will refer them to get further assistance and support.
All right. The Clerk of the Circuit Court of Cook County provides the participants in the judicial system with efficient and transparent services. This program is a means to that end. Thank you very much to our special guests, Attorney Amy Kessler from the Office of the Cook County Public Guardian and Attorney Cheryl Lipton from the Center for Disability and Elder Law today for their time and insights. That does it for this episode of Clerk in the Community. I'm John Zamuda, Chief Deputy Clerk of the Probate Division. Thanks for watching.